Good afternoon, Keith Tebow from FRCMedia. Thank you for joining us. This coming Monday, former Fall River Mayor Jasiel Correia is expected to return to U.S. District Court in Boston to face sentencing on his 21 counts, his convictions earlier this spring of wire fraud and tax fraud in terms of his Snow Owl app business and extortion and conspiracy when it came to his role of extorting money from potential recreational marijuana vendors. We want to talk a little bit about what people may expect from that sentencing on Monday. I'm pleased to be joined, as I have on many occasions since this trial began, by local attorney Steven Sabra. Attorney Sabra, thank you. How are you?
I'm great. Good to be with you, Keith.
Well, let me just ask, I know there's a lot to this, and we'll get into much of it during our short interview. But in general, what will happen when Mr. Correia reports to court on Monday in terms of what potential procedures may be happening in the U.S. District Court?
Well, there's a lot going on in this case, and a lot that the judge has to go through between on that day of September 20th. So I start with the interesting part of who will be representing him, and will Attorney Kevin Reddington, his trial counsel, be there? I think he will have to be, and he has two other attorneys that are handling the post-trial motion, so to speak, in his appeal. So it looks to me like what the judge will have to do, first of all, is sort out and rule on the defense motion for acquittal, or in the alternative, a motion for new trial. And the grounds of those pleadings, those motions, essentially are that the government didn't prove all the elements of the crimes of wire fraud and the tax charges. And the other part of their motion for acquittal, or more appropriately, the motion for new trial, is this issue of that, well, it's called misjoinder, and why the two kind of separate cases, if you will, the Snow Owl case and the marijuana related charges, why they were tried together. Now, once that's done, once the judge rules on that, then you get to the sentencing part, and the defense will, in all likelihood, go first and make their argument, as they have done so in their sentencing memorandum, as to their recommendation to the judge as far as sentencing goes. And then the prosecution will get their turn. At sentencing, you can have victim impact statements. You might have even people appearing that are going to give a statement in person at the court. I don't know that for sure, but they would have the opportunity to do that. And then lastly, it'll be up to the judge, and it's probably one of the toughest jobs the judge has, is to fashioning some kind of fair sentence. And then once he pronounces sentence, then the next issue, and you usually see this in the federal court, is whether or not, assuming there'll be some type of a jail term, whether the defendant goes to jail right then and there, which is more often seen in the state system. But in the federal system, oftentimes the sentence is stayed, and another date is set for him to turn himself into a particular location. And in the meantime, between the time of the sentence being pronounced and the time of the defendant having to report, the Bureau of Prisons will assess the defendant as to where he ought to go.
Yeah. Now, in terms of, the sentencing, both the government this week, the prosecution and the defense released memorandums in terms of their recommendations on sentencing. As you would expect, there's sort of, pretty wide gap between the two. The government is seeking 11 years in jail with 24 months, I believe, of supervised supervision after that time, when the defense is looking for 3 years in prison with another 3 years of supervised with supervision following that. In terms of those tactics, is that something that's typical, where there is usually a wide gap between what the prosecution is offering and the defense?
I'd say that's pretty typical. What I would say is the defense was smart in the sense that they didn't make a recommendation for probation only, for example. Their recommendation was 3 years in jail. So they were, I suppose, at least realistic as far as what their client was convicted of, and give the judge something to think about as far as whether that's fairer. But the judge, it's not a situation where the judge, for example, will go, okay, well, the defense says 3 and the prosecution says 11. I'll pick something right in between. It's not going to be that. It's not going to be like that. It could end up like that, but the judge is going to assess. Is going to look at what he feels is important in sentencing, which a lot of it in this kind of case, because it's a public official, deals with deterrence, a sufficient sentence to make sure that there's a message sent to others that if you engage in this kind of activity, there's going to be a pretty heavy penalty to pay. So it'll be interesting from a public standpoint, from a lawyer standpoint, as to what sentence the Judge Woodlock is going to give. And he has a lot of different factors to consider. One factor is what's called the federal sentencing guidelines, which are even higher than what the prosecution's recommended. So the prosecution kind of comes at this trying to look good, so to speak, and saying, listen, Judge, the sentencing guidelines even call for more than 11 years. We're only asking for 11 years, and here's why. So the judge is going to consider the sentencing guidelines, the prosecution's recommendation, and he heard the trial, he heard the evidence. He's going to consider everything from, as the defense has stated, the defendant's youth, but he's also going to consider, we're talking about 21 felony convictions. And as the prosecution mentioned, it's not a case where sometimes in the federal system you might have a drug case, or in the state system, a drug case, or some other kind of case where the defendant comes from a terrible background and there were mental health issues or addiction issues. There's none of that in this case. So that's not going to be a factor that's going to make the judge go sort of on the low end on the sentencing.
Yeah. So let me ask you, the government made a point that, the former mayor has not shown any remorse at all throughout this entire process. We talked about even, after he was convicted, he came out and said that, the truth will come out, being defiant throughout. And there have been talk that, there have been comparisons of other judgments with public officials, primarily State Senator Diane Wilkerson in Boston, former House Speaker Sal DeMacy. But in those cases, those public officials showed a little remorse. Could that play a role in terms of Judge Woodlock's decision, in terms of a lack of accountability or responsibility on the part of the former mayor?
That will definitely play a role. It was not an intelligent decision for the defendant in this case to make those statements that he made after the trial. I kind of understand it in the sense it's, you've just been convicted. It's emotional, but you want to, just say a no comment, or you're going to appeal, or he made comments about the fact that there were certain things that didn't go his way in the trial, which I can understand that, but he did not show any remorse, and he hasn't shown any remorse even really in the letters that he submitted. I think if you analyze the letters he submitted on his behalf, or were submitted on the defendant's behalf, I don't think I recall reading any remorse, that he expressed remorse to any of those people that wrote wrote letters for him. So his statement after the trial is not going to do him any good, and it's going to hurt him, and it's what the prosecution honed in on, or at least partly honed in on in their memorandum.
So let me ask you, we saw a couple of the other co-conspirators in this case get off without any jail time. Antonio Costa, one of them, as well as Mr. Camara, Hildegard Camara. In terms, and they both during their sentencing actually made a statement showing remorse and expressing their remorse for their actions. Is there a possibility we'll hear from the former mayor, or if he still remains defiant, will that be something that the defense attorney will say, maybe you don't want to say anything during this process?
I doubt you're going to hear from the defendant along those lines, because I think that his position is, I would think, that I'm young. If I get jail time, I'll do my jail time. I've seen other public officials be convicted of charges and still come back and won elections. I don't want to admit anything. And the other part of it is that he's filed a motion for new trial. He's filed a notice of appeal. So I don't think that that's something that we ought to expect. And by that I mean, I don't think we can expect the defendant to get up and say, I'm sorry, I apologize to the citizens of Fall River, or any of that. I just don't see that. I just don't see that happening. What I see happening is this case going on appeal, and his hope is that there'll be some reversal of convictions on appeal, or some order of a new trial.
Yeah, should be very interesting. We'll be following it on Monday, and I'll be looking forward to speaking to you sometime Monday afternoon as we get the sentence, and we can talk about the sentence and what it means moving forward. Attorney Steven Sabra, I appreciate your time as always, and we'll talk again next week. I appreciate it.
Thank you, Keith.
All right. And thank you for joining us on FRC Media. I'm Keith Tebow. Have a great day.